A part of our inclusion program here at SMCC is, while we want to support, our students, obviously academically and in their faith life, we want to try to support the whole family. And doing events like today is a step in that direction. Today with us, we have a special guest from the University of Notre Dame, Christina Jones. She's a clinical professor of law in a special education law clinic. So we're super grateful for Christina to join us all the way from South Bend today. So Christina.
All right, thank you. It's a pleasure and an honor to be with you today. Thank you for taking the time to join us and to join us electronically. Please feel free to ask questions as we're going through the process. I'm going to tell you just a little bit about me. So I am a Notre Dame law grad. I went out to Virginia for 8 years where I practiced special education law. I taught at William & Mary for a number of years doing a special education law clinic. I transitioned to the Marine Corps where I worked at Quantico and supported Marine families in special education and these kinds of guardianship type matters. I am licensed in Virginia, DC, Maryland, Indiana, inactive in California, but I'm not licensed in Michigan. So I can't take any cases in Michigan. My clinic doesn't take cases in Michigan, but I did speak with some colleagues who do and make sure that I understood the process. So forgive me if I miss any little things that are unique to Michigan, but I'm hopeful that this will still be an educational opportunity for you to understand how the process works and some things that you need to be considering as you're transitioning an adult with a disability out of these youth years. As a lawyer, I have to give a disclaimer. So there's my disclaimer. I'm not providing legal advice today, but certainly want this to be educational, informational. So please do ask questions if you have them. Right. So today we're going to start by talking about the guardianship process. You're going to hear me say the words incapacitated person or ward quite a bit because it gets used in the law. I know that's kind of a harsh term, but just know that we're talking about an individual with a disability who's about to, or who is an adult. We'll also talk about alternatives to guardianships, kind of understand what the gamut of options might be. I'll touch briefly on special needs trusts, and at the end I will give you a couple of organizations where you can look for attorneys who might be able to assist you in these matters. So for guardianship of incapacitated persons, I want you to kind of take a step back and think about any child when they are about to turn 18. Many of you have had that experience where that child becomes an adult and you no longer, as a parent, have rights to make decisions on their behalf. That might be educational rights, so records. It could be attending IEP or ISP meetings, hopefully those are familiar terms. Where they're going to school, if they're going to school, all those rights they get to decide sort of from there on out. That also involves medical rights. Do you have rights to their medical records? Can you call and make an appointment for them? Can you make decisions on their behalf? Also financially, right? These young people have accounts. They have they have to make decisions about how their money is being spent. So those decisions, as you transition into adulthood, become their decisions. Now, typically, when we're talking about a typically developing child, as they're turning 18, you might go and get a power of attorney to deal with some of these different issues. So that individual child retains their rights to make decisions, financial decisions, educational decisions, but they can also delegate that a parent or someone of that ilk has the ability to make those decisions for them. So they're not losing their own rights to make decisions, but they're saying this person can also make decisions on my behalf. You may have heard of medical directives. Some of you may have medical directives, right? That's another way to sort of be able to identify what you want to have happen in the event that you become incapacitated, or if you want someone else to be making decisions on your behalf. Okay, so how is this different when we're talking about an individual with a disability? Well, it depends on the extent of that disability. For some individuals, getting one of these powers of attorney, like you would for any other young person, will work because they're able to make decisions, they're able to understand what they're doing, how they're executing things, given that they talk to someone and can understand the paperwork. The issue with individuals with disabilities that are sort of more severely impacted by those disabilities is a question of capacity. So that capacity question is, does this person have the ability to understand what they're doing? Are they even able to make those kinds of decisions? So it's important to be thinking about what is this person able to do on their own? And we're not just saying like, oh, they make, there are 18-year-olds who make bad financial decisions. I'm sure there are, some 18-year-olds who have made bad financial decisions or educational decisions. It's beyond that. It's saying this person lacks the ability to understand the kinds of decisions they're making, to understand the ramifications of those choices. So in comes the law to give you an opportunity to substitute those rights and protect those individuals. So a guardianship for an incapacitated adult terminates that child's right. It terminates their legal personhood. So I know that sounds really, it's a grave thing that we're doing here in saying that this person lacks these rights. In order to get one, you have to go to a hearing, you have to have a court order. There's a number of steps that are required to take this kind of significant step and terminate rights. In Michigan, they use the term plenary or partial guardian, so you can say, we're gonna take all of the rights and give those to a parent or someone else that's going to be stepping in their shoes, or it can be partial. Maybe this person is able to make some kinds of decisions but not others, so the court will say, all right, we're gonna grant guardianship for medical decisions but not for residential decisions, for example. All right, there's also a term called conservatorship. So conservatorship is like a guardianship, but it is about financial matters exclusively. They have broad powers to invest, to lease, to sell, to take mortgages out, all these things. For a lot of the folks that we're talking about, my view is that this isn't necessarily needed because they don't tend to have an extreme amount of assets that you're trying to manage. I also like to tell parents that this process that we're about to walk through is the same process that you would go through for an 18-year-old with significant autism as it is with grandma who is having dementia, right? And that has a very different, kind of life experience, and that we're concerned about making sure that those rights are being enforced. So just to know that this term is out there, it could be possible in one of your situations, but most of the time you're going to stay in that guardianship kind of lane. So a plenary guardian is one that encompasses sort of all of the rights that an individual would have. That guardian would then step in the shoes of the individual and be able to make these kinds of decisions. If we're not talking about conservatorship, so like I just said, of thinking it may not apply in our cases, then a plenary guardian still has the ability to do some financial things. So they can receive your SSI or SSDI, they can manage some funds, make sure that there are funds applying to their care, support, education, bring legal action if necessary. But it's not going to involve quite the same bundle of rights that if you were to get a conservatorship. A partial guardian is one where the court is doing this sort of, we're going to take some but not all. I'm giving you this example of, they can make a personal choice about marriage, for instance, but they can't make a medical decision. I will say that I think these can be difficult when you're trying to say they are incapacitated. They're incapacitated enough to need a guardian, but not so incapacitated that they can't make some of these decisions. So when you're working with an attorney, they're going to work through with you what exactly is the most compelling way to sort of apply this to a court and make sure that you're not contradicting yourself. Okay. Just for background and kind of as another term to know is one called a standby guardian. So a standby guardian is someone who the court is saying is not the current guardian, but it's someone who, in the event that that current guardian is unable or unwilling to serve, so if they die, if they become incapacitated, your standby guardian can take the place of that guardian. Usually when I've done these in other states, I've recommended that that you appoint someone who is of the same generation as the individual that we're trying to get guardianship over, so that there's more continuity, right? That we're not having a continual change of guardian, and we can think through a sibling, a cousin, someone that can step in that place. In emergency situations, even without the traditional guardian passing away or being incapacitated, if they're unavailable for some reason, then that standby guardian can kind of take charge and make sure that that person is being taken care of. I think it's worth noting too that when we talk about guardianship, all we're saying is that we're talking about decision-making authority. We're not talking about who has custody of the individual, who's caring for the individual. That can happen in other ways. So you may have a child who is 19 with Down syndrome who lives in a group home, but the guardian might still be the parents, and the parents are still making the financial or other kinds of important medical decisions on behalf of that individual.
So with that being said, when you apply for guardianship,
Yes.
can you also apply for a standby guardian like you would
Yes.
a beneficiary or anything?
Right. So
You do
that's
that at the
and
same time?
yes,
Okay.
and you can always go back and add them later if there's if that changes. I had a case where they wanted to appoint a standby guardian who was a minor, but that standby guardian wasn't able to serve as a guardian
Sure.
yet, right? So you would need to adjust that. But I would frequently recommend that parents have a standby guardian. You can also have multiple, so you could have 2 guardians. You could have mom and dad. You don't have to pick one. And the same is true with standby guardians. I've had multiple kind of standby guardians ready to go.
And then, can
Yes.
we go back to conservatorship for a
Yes,
second?
yes.
Like, at what point, like, is there like a qualified item or something where like conservatorship is needed for kids instead of disciplinary?
It's hard for me to give you like a really what you're looking at is if this is an individual who has property or has assets that are kind of larger than just, I'm getting my social security, I'm getting my, benefits from the state, then you might be in a conservator kind of posture. Do you have someone you're thinking of or an example that you're considering?
No, it's just, I mean, that's like, he's not getting that much from me. It's more of like, at what point is conservatorship necessary or, suggested as opposed to it just, the financials just being covered within the guardianship?
Right, so I think I would tell you that that's a good individual fact situation that you would consult an attorney with, but in my view is that I've done this for a lot of individuals with disabilities. I haven't had to go the conservator route because they didn't have property, assets, they weren't inheriting a whole lot of it. It was much more about the decision making and kind of the smaller kind of financial decisions. And we'll talk about why you want to limit the assets that individual might have toward the end. Okay, thank you. All right, so when you're filing for guardianship, you file a petition with the court. The petition has to include certain things, including basic information about the individual's condition, why they are not able to make these kinds of decisions for themselves. You can file for guardianship and conservatorship at the same time, but you don't have to. But they do have to be in separate petitions, so there'll be kind of two things that are happening. So in terms of timing, so this can be kind of tricky. In some states, Virginia, where I previously was, there was an opportunity to file for this before the person turned 18, so the child was covered by the time that they turned 18. You knew who was taking the place of that individual. In Michigan, it is only, you can't get it issued before the child's 18. So what I've had some colleagues suggest is that they file it right before they try to set the hearing date for the 18th birthday or right around that time, so that then there isn't a gap of who is making these kinds of decisions. Yes?
That was a question that came from one of our parents previously. They had this experience with one of their children, and there was a gap. What happens in that gap?
Great question.
Honestly,
you're kind of at the mercy of whoever you're dealing with, which is a very scary situation for some. So I was part of a situation where a family didn't seek this until the child was in their 40s. It doesn't change the process at all. The process is exactly the same. But what happens in that interim, unless you have a situation where the person has already executed a power of attorney or a directive or something, then really that individual still has their full rights to be making those decisions. Frequently, there are people that you're trying to engage with, schools perhaps, or doctors' offices might kind of give you the courtesy of continuing to have the parent be involved, but they technically are not supposed to be doing that. They're supposed to be limited against the individual. So this is why we want to get ahead of these issues so that you don't have a situation where someone gets into a car accident at 18 and 6 months and the parents aren't able to kind of come in and make decisions on their behalf.
so do you have a sense with Michigan how far in advance of the person's 18th birthday you would want to wanna start this process? How long does the process itself take once?
Good question. I think it's gonna really depend on your jurisdiction within Michigan, so I can't give you a clear. What I always did with families is I asked them to come to me when the child was 17 to 17 and a half, because that would give me enough time to kind of go through. But I would recommend, let's find somebody in Michigan that could answer that question locally, that would understand how the local practice works.
And what about filing costs?
I wanna say it's $150 to file, something like that. Your cost is going to be more borne out in the legal fees, most likely, than it would be with the actual filing. I don't know if there are other court costs involved, but the filing itself is pretty low.
Is this something that we could do as parents on our own, or do we have to have an attorney?
You don't have to have an attorney. I think I would advise you to have an attorney, but I was thinking of your advice, I am. But I will say that I think because you wanna make sure that you're checking all these boxes correctly, it's something that you should only have to do one time, unless you are gonna move and then that causes jurisdictional. If you change states, then you have to kind of deal with them again a little bit. But if you are staying here, then I would encourage you to consider like the investment of taking care of this from an attorney.
Is this something that needs to be published so that other parties are notified that this is happening, or once you're in this process?
Great question. So there is a notice requirement, so when you put out a petition, there are certain individuals that have to be notified. So again, using my example of like grandma, it has to be like a spouse, adult children, adult siblings of the individual have to be notified. If you don't have anyone that falls into that category, you have to have at least one adult relative that is aware that has been served. The individual themselves gets served too. I'll explain that process in a little bit. But those are the individuals that have to know. Once you come out of the guardianship process and you have your guardianship, you'll have a court order that you can then take to other places. But it's not like you're gonna see it in the newspaper or that it would necessarily be published in, a court report kind of situation.
Well, I'm obviously specifically asking as ex-husbands that don't see the children or have anything to do with the children.
So if the child file, that person would have to be notified that it was happening, that the guardianship was happening, because they have to, the rule, so they would be informed at the stage of, I filed a petition, here's the notice of the hearing, they have to have an opportunity to object. So they could come and try to petition the court otherwise, but they do have to be informed. Unless the individual's rights have been terminated. Yeah,
Does custodial standing have anything to play in there? If you had a parent who had custodial rights revoked, would they still need to be notified?
I believe it's biological, but I'm not 100% sure on that. But that's usually how it goes. Sorry, I wish I made these rules. It could give you better answers.
I don't know where he's
yeah.
at, I have to go and locate him, and it's just.
So that's again where I think having an attorney local be able to advise you about what the practice is in this area would be really helpful.
I just did this in Monroe County. The people at the courthouse were wonderful. I did not use an attorney, and they were absolutely wonderful. I had to do all kinds of what you're talking about, but you have to list the people that you are aware of that are related to them. It's pretty easy. Monroe County, not Wayne County, but Monroe County
Oh,
is
he's
pretty.
not, he's in.
I mean, it's wherever you file.
Ah.
And they were wonderful and very helpful.
Yeah, I don't even know what county he's in, honestly.
So if they're unable to be located, I think you may have a different story, right? Than if it's somebody that you have an address for. Yes, ma'am. Do you have a question? Okay.
You also mentioned a minute ago that it's permanent, so once it's filed and established, then it's granted, then there's no need to go back and do it again later at some point?
That's right, and so there are a couple exceptions to that. So for one thing, you have to file an annual report, so that's just stating what occurred in the case, you moved this person to this place, they had this medical thing, something to that effect, but it's not to reopen the guardianship. An individual themselves can try to reopen it and contest the hearing, or contest the guardianship at that point if circumstances change, or if they just want to, they have the ability to do that. Someone else can try to change this. But if they don't, if you're in kind of a standard situation, it's usually one and done. I will say that in some states, we're starting to see more of an emphasis on having like rehearings after a certain amount of time, 1 year, 2 year, 3 years. That's not, from what I understand, that's not what's happening here. That could change. But I will say that in that situation, I had a case that had one of those sort of rehearing things. You can waive it if you can prove that it would be unnecessary and burdensome. which most of the time it would be in the cases that we're probably talking about. But if you had a situation where a child, made a miraculous recovery or something to that effect, you want to have the ability to kind of go back and make sure that their rights are not unnecessarily restricted. So it is usually kind of a blended term. Good question.
Just
Yeah.
to clarify, for example, I think at 18, my son he doesn't have the discernment for medical or financial. I think maybe that'll come along later, maybe 10 years later, let's say. At that point, if he appears to be able to make those decisions, we can reverse it.
You can ask the court to, yes.
Okay.
Yes. And you can have another party come in and try to assist with that. So that can be a good opportunity if you feel that that's something that with further
I'm
training
hopeful.
and education, right? But I will say that when you're petitioning the court for the first time, I'd probably keep that idea to myself, right? Because you kind of have to, I think many of you have probably been in IEP or something along those lines kinds of meetings, right? Where all you're hearing is the really difficult stuff. That's the kind of stuff that's gonna make it into a court report, right? Because you need to show them on their worst day so that you can determine that the child is in fact incapacitated, or the adult is incapacitated and doesn't have capacity to make those decisions. Okay, so if you are dealing with a person with a developmental disability, so that's like an intellectual disability, autism, Down syndrome, something of that ilk, then there has to be an evaluation from a medical professional that includes a functional assessment and has the diagnosis. That is something you can file with the petition, or it's something the court can order after an initial hearing. I would, in theory, I think you'd prefer to just have it done ahead of time and take care of it, file it as part of your petition, because frankly, a lot of your evidence is going to come from here as to why the child needs this kind of guardianship, this order put in place. Yes?
Psych-eval?
Psych-eval counts. Yep. Certainly you can go through insurance for things like that, hopefully. But there's also, we can talk about the school kind of side of things too.
How long before you file that does the psych-eval need to be valid?
It wasn't in it wasn't really clear in the law, so I can't give you a firm answer.
Are we talking within 5 months, 6 months, 3
That
months?
seems reasonable to me in that
So
ballpark.
within 6 months?
That's what I would do, but I would, again, I'd check with your Michigan.
There's not a whole lot that's gonna change with them in 6 months.
Right. Okay, so we've talked about the guardian, so that's the person who's assuming the rights of the individual. A guardian ad litem is an attorney. So it's an attorney that represents the court and is sort of helping them with their fact finding. It is not an attorney that's representing the individual that's incapacitated. It can look that way sometimes, but that's not what it is. It's somebody that's appointed by the court, unless the person does obtain their own counsel, then they'll kind of not appoint that person. This person has to visit that individual, and there's a whole lot of rights that they have to explain and the process they have to explain, so we're gonna talk about that next. I tell you this because some of it may seem silly, because the person that you're dealing with probably doesn't have the understanding or the ability to understand what's going on in these situations, but it's a requirement, so they're gonna have to work through it. I've worked with a lot of really good guardians ad litem, who are really well versed in trying to explain it at the individual's level. So they have to explain nature, purpose, legal effects of the guardianship, what the hearing is going to be like, that they have a right to contest the guardianship, that they can request limitations on those powers, so they could do one of these partial kind of guardianships. They can object to the person, so maybe they don't want mom to be the guardian, they're okay with dad being the guardian but not mom. Or they object to their sister or brother being listed as a standby guardian. They have a right to be present at the hearing. That doesn't mean they have to be present at the hearing, but they have a right to be. So most of the guardianships I've done, the individual is not there themselves, but again, that was a choice of the family and that individual. They do have a right to legal counsel. If they're indigent, court-appointed counsel can be provided. They have to discuss that medical authority that a guardian would be assuming. So a guardian could put in place a do not resuscitate order. They can also put in place a physician order for the scope of treatment. So the individual needs to be aware that these things could be kind of imposed on them by this guardian. They have to inform everyone that, of the people that are involved as guardians or standby guardians, give information about the financial situation of that person, this is mostly for the conservatorship person, but they have to be able to explain what those accounts look like. And they have to determine that the other alternatives, the less restrictive alternatives, are not appropriate in that circumstance. Okay, again, my reasoning for telling you that is that it helps if you're the person seeking the guardianship, if you prepare the individual that this is going to happen, and these are the kinds of things that are going to be discussed, so they're not taken aback, because you don't want them to come in and say, to be surprised, or to be really against a particular kind of thing that you may be seeking. All right, so we talked about the notice. So the individual themselves has to be served personally. So usually in other states it's that the guardian ad litem serves it. I'm not totally sure who serves it in this case, but that's usually the case. We talked about spouse. If the person had put in place before seeking a guardianship a power of attorney, then whoever is listed as the power of attorney would have to be notified. I would not suggest doing that, and we'll talk about why a little bit later. All the people that are named in the petition basically need to be informed. So anyone who's being listed as a standby guardian needs to get notice that this is happening. And then if we somehow don't add up all those people to one close adult relative, you've got to find somebody else. So I've had aunts, uncles, cousins kind of fill in that role. Okay, we've talked about a number of these things, but it's important for you to know that this individual does have the right to request a jury trial. They have the right to present evidence. They have the right to cross-examine witnesses. My experience has been that those things don't happen, but it is a possibility that that individual, if they are trying to contest the guardianship, that they may go that direction. And again, these are things that the guardian ad litem is going to tell that person that they have the right to do. My experience has been that these hearings are generally closed, so they're not open to the public, but it is a request that gets made, and the parties need to be sort of clear about what they're seeking, if it's going to be an open or a closed hearing. Okay, so we've been talking a lot about like the guardian sort of just, you filing a petition and it kind of happens, but let's talk about what it is that the court actually has to find. So the standard is clear and convincing evidence. By the way, that's less than beyond a reasonable doubt. That the individual is in fact incapacitated, and that a guardianship is necessary for the continuing care and supervision. So you can see here a definition of what an incapacitated individual is. We talked about people with developmental disabilities. That's sort of in that mental deficiency age, but there are some other things. The important part is that they lack sufficient understanding or capacity to make or communicate informed decisions. All right, so how do the courts look at these things? Again, you're going to be trying to make those things clear. The guardianships again are restrictive, so we are going to look to see if there are ways to keep the child involved in the adult. They need to be in a way that we're not going to be cutting them off from the rest of the world, right? We want them to still be involved in your decisions, but you're taking, as a guardian, taking the ability to protect them from malfeasance, basically, or things that could go awry. All right, so what about the guardian side? The court does give preference to family members in the appointment of a guardian. When you're filing a petition, you're recommending, usually the person filing the petition is the one that's seeking guardianship. It doesn't have to be that way. It could be an organization that you want to be a guardian. It could be an organization that's seeking guardianship and petitioning. Parents are usually kind of top of list, so if you're a parent that's seeking guardianship, that's kind of the standard protocol. If those parents are unsuitable, then you can certainly find other folks to fill that role. The guardians are supposed to be making decisions in their best interest, of course, but encouraging them to be part of the process. We talked a little bit about that annual report. So once a year, they also have to provide it to the person, to that incapacitated person and interested parties, so kind of going back to the people that require notice. The report has to include sort of how, basically the individual's condition, if there have been any significant changes, if we're changing living arrangement, if there have been medical or mental health treatment that's been going on in that past here's some more. Did you execute a DNR, do not resuscitate, or a physician order for treatment? Did anyone, what the guardian did, should the guardianship continue? So here would be an opportunity if you said like, I don't think guardianship should continue because he's able to make these decisions. You probably put it in your annual report first and then file deal with undoing some of these things. If there's any kind of financial coordination, if we're talking about a conservatorship, that we most of the time not going to.
Will you dive in what services received means?
So, services received would be like, child's going to school, the child is getting occupational therapy, the child is, and I'm saying child, adult, it's meant to be like any kind of therapeutic sort of service, if that makes sense. You don't have to have those things necessarily. And then I think it's good to know, like, I think they want to just be able to say, like, it's not as if the person is staying in the basement forever and walked away, right? Like, that they're engaging in the world. Okay, so guardians can do a lot of things, but there are some limitations on what they can do. So they do have to go back to court if they're trying to make a major decision along these lines. So if you're trying to put them in a nursing home, if you're trying to put them in an inpatient medical or mental health institution, unless it's expressly authorized by the court, so that's where your attorney might be able to do that.
Can they agree to voluntarily sign in even though they have a guardian?
I don't know the answer to that question. That's a really good question. I think my inclination would be probably, but I think
I know mental health laws are strict.
yeah, that's a probably a state question too that I probably can't answer. Sorry.
It's okay.
If you're going to be moving out of state, you have to ask the court to be able to move out of state, or you need to kind of moving within Michigan. Something just to know, so I dealt with military families that were moving a lot. You kind of have to go and decide if you're going to, if they were going from, Quantico, Virginia to Camp Lejeune, North Carolina, they would decide, like, are we gonna keep the guardianship in Virginia and just sort of give it power in North Carolina? That was one process. It was pretty straightforward, some paperwork, didn't have to make an appearance or anything. If they were trying to transfer it there completely where Virginia lost jurisdiction and there has to be some notice back and forth, and there can be a little bit more. So it's just important to know that if you are moving out of state, it's not like, okay, we just take it and it has full effect. The state has to give it, that court has to exercise jurisdiction.
So let's say I find an amazing program for adults in Ohio. She moves to Ohio and I stay here. I'd have to still file in Ohio again or notify Ohio or?
So you would probably need to go to court to say, I want to move her there. And then you would probably need to, my thought process would be, you would consult with a Michigan and an Ohio attorney to make sure this all went the right way. But usually, my instinct would be you probably want to have it in Ohio so that the child was, unless you felt like it was a short-term thing. If you felt like the child was going to live the rest of their life in Ohio, then we're not. They were going to live just a very short portion of their time in Ohio. Keeping it in Michigan makes sense. You still have to tell Ohio system to say, yes, I'll give credence to what's going on in Michigan. But we're not going to exercise jurisdiction. In other words, we're not going to take your annual report. That's what's going to stay in Michigan. So it just sort of depends on what the individual situation is. I know this is tough when you live on border state and you're close. Did you have a question, sir?
No.
Okay. All right. So we've talked a little bit about modifying or terminating a guardianship. So I think I won't go over it into too much detail, but it is the same standard of this clear and convincing evidence, and whether the guardianship remains necessary. That individual that is under the guardianship can make that, or any other interested person. So you can try to adjust it in that way. There's a little bit more. You would have to present evidence that that ward has regained capacity, so the ability to make some decisions, or that the scope of the guardianship exceeds what's needed. So, and your situation. Okay. The guardian can also be the one to initiate it and say, I'd like to resign. this isn't working for us. And the court can also remove a guardian if there's a cause, if there needs to be an appointment of a successor, if you do not already have a standby guardian. So that's another reason to put a standby any questions about guardianships before I get into alternatives?
For the annual report and some of the kind of consistent things that you file with the board, is it something that typically like an attorney is doing on behalf, or is something that?
I mean, for what it's worth, in Virginia, when I did these, the parents would fill them out, I'd look them over real quick, but it was mostly to be their comfort. Like, I didn't need to be involved. As long as they were kind of going through it and me answering the questions. A lot of counties have forms, so it can be really clear as to what exactly is being asked. But you're not really at risk of them saying, oh no, like, unless you put something like, you know, I'm never seeing this person, they're not involved at all, like, they're making all their decisions. It's not the same level of kind of scrutiny that you're gonna have when you're first trying to get guardianship. So you don't have to worry about, did I say the wrong, you know, did I not dot my I exactly right? So I don't think you necessarily need an attorney in that situation. It's really just that stage that you're really.
What, like, who, where does it go at the court, like, what department?
Good question. I don't know the answer to that. I can tell you in other states, it's like the county social services sort of thing, and the court gets a copy or something to that effect. I'm not sure. I think your county is. Okay. All right. So now we're gonna talk about alternatives. So some of you have durable powers of attorney, so I probably don't have to explain all of that to you. But durable is something that means that even so, if you sign it today and you have capacity, but you lose capacity tomorrow, it stays in effect. Okay. So you're allowing that other person on at the time that you're becoming incapacitated to make decisions on their behalf. You can make them for financial decisions or general decisions. You can outline exactly which kinds of things you're giving power of attorney for. So you can customize it to your situation. You can have different ones for different things. The other is sort of Michigan calls it a patient advocate designation, but it's a medical power of attorney that authorizes that person to be making medical decisions, including end-of-life care or mental health treatment if that person becomes unable to do so. This is going to limit that medical decision-making powers that are guardian.
So.
Yep.
She was kind of getting to that, so would that be something for that situation where she was worrying about their child's ability to sign into a hospital on their own, or is that, am I going the wrong direction?
So if the individual is, so these kinds of things come into effect if the person themselves, okay, let me back up. In the situation that I think she was describing where that can a person sign themselves in?
Right.
The question is like, do they have the capacity to sign themselves in, right? Do they understand what they're doing? Could someone with medical power of attorney sign them in? Yes, but you would never have a guardianship and a power of attorney. Your guardianship is going to overtake the power of attorney. But you could have a medical power of attorney that's more narrow in scope of what you're authorizing that person to do, compared to what a guardianship would have for kind of broader medical considerations. Okay, so a power of attorney has to be in writing. It's got to be signed, dated by the principal would be the individual that's granting the rights. It has to be witnessed by 2 adults. So it's not a heavy lift. People execute these without attorneys all the time, but you can, if you want them really tailored in a particular way, then I would recommend having something like that. Okay, there's a concept out here, it's becoming more and more popular, called supported decision making. Has anyone heard of this? Okay, so supported decision making is, oh, I'm sorry, did I skip one? I did. All right, sorry. Let's see. All right, we don't have to worry too much about that. Thank you. All right, supported decision making is a movement to try to not take away people's rights through the guardianship process, but to find less restrictive ways to do this. Supported decision making is something where it's sort of like getting a community of people together to support this individual and help them make decisions. This is really popular among some disability rights groups, particularly out east and out far out west. Disability Rights Michigan has a lot of information about this if you're interested in kind of the local issue. The challenge with supported decision making is it can be done through like a hodgepodge of powers of attorney and that kind of thing, but it doesn't have to be. It can be more informal. formal than that, and it can still kind of fall under this banner of supported decision making. I will explain why this is something you need to think about before you do. You can have an agreement, however, the law in Michigan does not exactly state this. So it doesn't give legal force. So if you took a supported decision-making agreement to a bank, like they don't necessarily have to honor it. To a school, to a doctor. They're not gonna get in trouble with the law for not honoring it in the way that they would with a guardianship, or even with a power of attorney, so long as they're clear that that person understood that they were executing the power of attorney. The supported decision making, some states are starting to recognize these things and codify them into law and give them more effect. Just Michigan isn't there. Whether it will or not, I can't tell you. But it is something just for you to be aware of that they do exist. I tend to be nervous about them. Yes, did you have a question? Oh, okay. Okay, are any of you representative payees for federal benefits? Does anyone know that term? It's basically like you in order to assist with the adult with a disability social security, you get appointed to handle those kinds of financial things. This is something that you don't, I'm sorry? Okay, this is something that you don't have to go to court to do. It's something you can get done through Social Security, where you're the one that is, you get the funds, you manage the funds. If you do have a guardianship, then you could do that too, but this is sort of another kind of less restrictive way, if that's the only concern you have is about the Social Security payment. Okay, yes, you look like you've got a question.
I guess I don't understand how somebody can just be like, no, I'm gonna take their money, like without any legal.
It's a process through Social Security because they're already deemed incapacitated in order to receive Social Security benefits. So we're talking about like an individual with disability. We're not talking about like regular, I'm turning 65 and getting Social Security or whatever the age is now. But the disability payments, there's a process that you can go through with Social Security to become the reparate payee so that the funds are coming to you to manage for that individual. My aunt is a representative payee for my cousin with autism. Very standard process. It doesn't require an attorney, doesn't require a court order. It should be pretty straightforward. But you don't necessarily have to do, you would still be the rep payee if you got a court order to be the rep payee, but you can also do it in rep.
It's a scary thought, isn't it, that they could be financially abused?
I mean, I hear though, because what they're saying is they qualify for Social Security based on the disability. And so there isn't, so you shouldn't be able to like force them to have the actual, what is,
Like the
guardianship,
court,
sorry. Guardianship in order to receive the benefit. Because otherwise, that's what would happen, is parent couldn't receive the benefits until after the guardianship, or only the guardian could receive it. So it does make,
But see, I think what you're getting at is like, there are all these systems that don't talk to each other,
Yeah.
right? And also, I think it's worth noting, these guardianships it is to sort of make the parent's life easier to be able to navigate these things, but it's largely to protect the individual from abuse situations, so that there is a clear decision maker. I remember when my family was going through it with a cousin of mine, there was this like fear that she was just gonna say, yes, I'll marry you. Like, she wouldn't know what that meant. But because there's something in place, like she couldn't do that, right? Or that she was going to mistakenly execute a contract and say yes to something that she shouldn't have. You can undo it when you have a guardian. So there are ways, I think it's important to recognize that this is not just meant to be sort of like, let's make this easier, but it is supposed to try to keep it clear of who is making the decision and who's able to make those decisions for them.
is there any kind of annual report that's needed from like the payee to the exercise system?
I don't know exactly if it comes directly from the pay, but I do know that you have to stay, the individual's income has to stay under a certain amount. And so if they kind of track if that income increases. I don't know exactly what the reporting is, but trust me, like if you go $10 over that limit, like they're gonna come at you and try to take back some of that money. So there is constant communication between the rep payee and Social Security.
Well, I was thinking more of the document, like how the money was utilized.
So I wish I could give you a definitive answer. I'm sorry, I'm not an expert in that. But I think my understanding is that you do have to keep records of how you're documenting. I don't know what the auditing kind of system is like. right, educational rights, so, you can, in theory, you could execute an educational power of attorney, just because you can execute an power of attorney for kind of anything. So, one of the things for students who are in public schools, we worry about, once they turn 18, that the school district is gonna say, great, like, do you wanna go to school anymore, Johnny? No? Great, out you go, right? That the parents would have the rights to be in the meetings, to keep them in school, those kinds of things. Some states have sort of another mechanism, educational power of attorney that they directly recognize. You can kind of do it here in Michigan generally by having a document that does those kinds of things. I recognize that most of you are affiliated with private schools, so you're probably not worried about what your private school is going to do when that child turns 18. However, there can be implications. I think it's important to recognize that you have a right to a reevaluation. So when we talked about these psychological evaluations, the public, even if you're a private school student, you have a right to have the public school reevaluate your child every 3 years. They're supposed to be doing that, unless you jointly agree that you don't want that to happen. You can also ask for it more frequently, but you can't ask for it more than once a year. If you do not have the ability to, if you don't have a power of attorney or guardianship after this child turns 18, it's going to be harder to get that kind of thing done. However, my point in telling you this is mostly to say, in the event that you do not want to go through your insurance company to get a psychological evaluation, you can ask the public school district to do an evaluation. You can then choose to disagree with their evaluation. Standard is pretty low for what that means. And then you can ask them to pay for you to get a private one done. So it's like a free second opinion. They can technically deny it and take you to a hearing and say that their evaluation was appropriate. My experience has been, I do this all the time. My experience has been they don't do that because it's harder for them to fight it than it is for them to just grant and take care of your psychological or educational evaluation.
It's when our son was in the public school system through 4th grade, there were many times we had to open the IEP to readjust because he needed his goals adjusted. And it was really hard just to verbally ask. I noticed after learning the law for special education and getting the advocate's manual, taking the mock letters and plugging the information and made things happen a lot quicker.
That's right. Yeah, I'm not surprised.
A lot quicker.
Yep, absolutely. All right, so we've talked about guardianship, alternatives to guardianship. Let's talk about special needs trust. Is anyone familiar with that term? Okay, are you familiar with the term of a trust? Anybody have a trust? Okay, so when you're talking about individuals with disabilities, we talked about that they get them in part because they are low income, right? So Social Security gives you a supplemental security income that is due to their disabilities or older adults who have little to no income. You can see right now it's under $2,019 a month. That gets you kind of, it's one of the criteria that gets you qualified for these benefits. Medicaid also offers publicly funded medical coverage because these people are considered low income. So these benefits, probably some others mentioned, yeah, I don't know, are means tested. So that individual's income needs to stay under a certain amount. That includes their assets, not just their, what am I making every day. So you could have an individual with a disability who doesn't have a job, but because someone left them some money or gave them some money, they're gonna be above these thresholds. And that would disqualify them from these benefits. Yes?
What about if they still live at home with their parents? Do they look at our income?
No, they look at their income.
Okay.
Yeah. So and that's something that you have to kind of go hash out with Social Security. You'll explain all their expenses. At some point, you'll kind of have to show them that, like, what the rent would be and all these kinds of things to sort of make it clear that their income, their assets is less than a certain amount.
I'm thinking of a former student right now. I'm seeing if my example matches what you're talking about. So the student had grandma and grandpa left him money for when he turns 18, so that's gonna go against him.
Mm-hmm.
Okay.
So that's the problem, and that's the problem that a special needs trust is going to solve, is that very well-meaning people, including parents, are going to want to leave money to this individual to take care of them, but the way that the law is unfortunately structured is that will disqualify them from a number of benefits, because now they have money to pay. But in reality, like, they're still entitled to, they need these things in order to, move forward in life, get their medical coverage taken care of. So, that helps us get into special needs trust. Yes, sir.
Under the circumstance, he said, would that now adult be eligible to apply, let's say, in 5 years if they ran through, or their family ran through that money?
Good question.
Because now they're no longer
I mean, I
having money.
probably, I don't have a clear, I don't know I can't give you like 100% definitive answer, but I would say probably, but they do some degree of look back. I don't know what the timeline is.
So it's usually 5 years, just to go back like for WAGA for Medicaid, when
Yeah.
people, it's 5 years, they look back into their finances, so within that 5-year period, they can be disqualified for moving money, losing money, spending money.
Right. But it's money that's in their name. It's not family money. It's money that is explicitly for their purpose. So, special needs trust can have that. It's basically like it's a shelter for these kinds of assets. Anyone can leave assets to a special needs trust. So it could be grandma, grandpa, it could be a parent, it could be a friend. I know in families, they usually, once they get these, they send letters out to anyone who they could possibly leave the child money and say, please don't. If you're going to do it in this way, send it to this trust, as opposed to this. So what you do is you appoint a trustee who's going to manage it. It could be a sibling, it could be a family friend, it can also be a professional. So there are organizations out there that will be trustee for a special needs trust, whether it's a bank. There are some chapters of the ARC that do this, where they support, they have these kind of pooled trusts they'll manage, kind of making sure that the person is getting their disbursements for their needs, that they're getting money for clothing, and that they're going on trips and they're getting sort of the funds directed toward them. Yes.
So in theory, you could leave assets as long as those assets
Are in
don't
this
have a
fee.
passive income greater than $2,019 a month.
I'm just gonna say you're playing with fire if you do, because these numbers could change,
Okay.
right? This is an easy way to just make sure that that's not gonna be an issue in the future. The trust is going to then, I mean, for those of you that have trust, like you understand, like they're making disbursements, that person is still gonna be taken care of. It's just a matter of making sure that you're not also disqualifying the person.
So you put the money into the special needs trust to keep the monthly flow.
Exactly, got it.
So when it gets dispersed though, is it just like as cash payments, so you don't have to report it, or how does that not affect what they're doing?
So because you're paying the expenses, so it's sort of like, my understanding is it's kind of like a reimbursement situation as opposed to, the trust is actively paying for vacation,
It's
whatever.
good for taxes too.
And that's
It's,
just getting them spending money.
yeah, are you an accountant?
No.
Oh, okay, alright. Spot.
No.
Do you have to do a one lump sum with these trusts, or is it something that you can just continually contribute to?
I believe you can
You
continue.
can continue to
But
fund
it
them.
but can also be something that doesn't get funded until your death. Like, you don't have to have like, an ongoing payment to sort of fund the trust.
You may not know the answer, but there's a MyAble
Yes.
system in the state of Michigan. Is
Yes.
that the same as the special needs trust?
No, so an ABLE account, so ABLE was sort of it was an act that was passed by Congress to try to deal with this ridiculously low monthly income you have to hit. It allows you to save a little bit more in a sheltered way, but it will work for some people, it will not work for a lot of people who want to be able to leave like significant assets to an individual. It's more of like, we don't want these people to not be employed, and we don't want to discourage them from having jobs, but if they have some level of income that's still fairly low, but more than 2,000, then an ABLE account could be appropriate.
It's a
And this
shelter
is again where, so, I promise I'm not in the business of just drumming up more business for lawyers, but truly, like, you want someone who knows the ins and outs of tax law and these kinds of things to be able to manage. Okay, is an ABLE gonna work? Is that appropriate? Do we need to actually go through a special needs trust?
And I think, correct me if I'm wrong, but you can roll a 529 into an ABLE account, correct?
I think you're right, but
Yeah.
not gonna say with 100% certainty.
Can you set up a trust before they're 18?
Yes. Okay, so here's my cautionary tales. Please do not leave all the money to one of the child's siblings and say they'll take care of them. Because,
Well, there goes my plan.
so let me tell you why. That individual, that child of yours could be they become the assets of the individual, that the sibling, not of the child with a disability. So you can't protect it. Or, you know, if you have a situation where that sibling gets married, sibling dies, the money maybe goes to the spouse, there's no guarantee, you can't guarantee that it's going to actually benefit the individual. So the trust is a very important way of just making sure.
I just gotta live one day longer than my special needs child and we'll be okay. One day longer.
You might have this someplace with the difference between a special needs trust and then a trust.
So it has to do with this whole issue. If you don't have a special, most people will recognize what I'm saying as a special needs trust. Sometimes they will call them something a little bit, it'll be a trust, but they create these kinds of provisions in them where it is not gonna count against the person's income. It's for their benefit, but they can't have control over the money, that individual.
And it's recognized nationally, it's not something that you need to be concerned about moving.
I mean, so I think you probably you would wanna make sure if you move to a different state, but you wouldn't have to worry about it within the same state. If that makes sense. Okay,
You move to California, all bets are off.
It's my kid, we're going to Florida, what are you talking about?
So, yes.
It was established in a different state. I can still contribute to that.
Yes, ma'am, absolutely. All right, don't just think if I did some kind of trust that that the benefits are gonna be the same, because again, that could lead to that individual then having assets in their name. You don't wanna do that. Also, I caution families, please don't go to just a general estate attorney. Make sure that they know about special needs trust specifically. You need to ask that question, and I'll tell you in a moment how you can find a list of them. But it's really important just so that, because these things get really difficult. Is anyone military affiliated here? Okay. If you were military affiliated, that's another kind of thing you wanna make sure, because their survivorship benefits get a little long. Okay, how can you get help? All right, Special Needs Alliance is an organization that vets people who do special needs trusts. So there is a list, there's a directory where you can find people who, I've been told that they've had to like sell a kidney in order to be on this list. Like it takes a lot of work to be recognized as sort of an expert on this list. Many times these same attorneys or their same firms do guardianships too, so you can kind of get it all done at once. Most of them will also do just your general estate planning and all the other things that you need to do to take care of other children or other funds that you may not be dispersed in special needs trusts. There's also an organization called the National Academy of Elder Law Attorneys, which is mostly elder law is going to definitely cover guardianships, may do special needs trusts, may not. But these are good places to look in order to find it. Yes, sir.
Just wanted to add a public service announcement. Some of you are familiar with the group that's begun through the Catholic Foundation of Michigan called the St. Margaret of Costello Fund. This is a body that's begun in the last 2 years, and their focus is to raise money to build inclusion programs at Catholic schools across Michigan. It's the effort was started by 2 attorneys from Detroit. One is the head of Butzel, which is one of the largest law firms in the state of Michigan. Paul can't be here tonight, but he referenced the fact that they have access to, I would assume it's the Special Needs Alliance, and he mentioned being able to refer any of you to attorneys who specifically practice in this area of law. So we want to be able, in follow-up to this, we want to be able to point you in directions, maybe to get some counsel. There used to be an attorney here in Monroe who had done this for a very long time, was very good at it. He's since retired, and we probably sit and have coffee with you and talk to you about it, but can no longer do this and give up his law practice. So.
Right. Thank you very much. That's very helpful. Any other questions? You've been a very engaging audience. Thank you for the questions. I'm sorry I couldn't give you all of your answers, but I would really encourage you to really think about how you want to be preparing for these next steps, because the worst thing you can do is nothing. You want to make sure that you're being proactive for the sake of your kids, and they'll give you a lot of peace of mind.
Any places that is such a lacking resource? You know, most of us have obviously disabled children or autistic kids at this point, and there's nothing for them to move forward to. If you're not able to keep them at home, or the group home settings in the area are horrible sometimes, what else is out there? Is there something that we know about that maybe it's a long lost secret that nobody wants to share? I mean, I don't know.
Let's just put Connie and Jake together somewhere.
Great.
I need a special Google.
Think it's something, there's got to be something that we're missing, that it's there, but it's so hard to locate.
I know. Do any of you know? I mean, some of you have probably navigated these channels. How many local
I
referrals?
feel like all the group homes that I know of they're pretty secret. It's not like marked like, you know, a physician's office or a hospital would be.
They're more
There's-
privately owned in Michigan.
Yes. So your, do you all have like community service boards or your kind of agency, state, local agency that has like a caseworker assigned to your?
Yes.
Through the ARC.
In
Okay.
Monroe County, Monarch in Monroe, like, for you people in Monroe County, Monarch has all of that, but also if you live in Monroe, then you have mental health, I don't know what it's
The ARC?
called. It's
Mental Health Authority.
the Mental Health Authority, you'll have a case with them as well as the Monarch people, cause
So they're supposed to be helping you navigate
Yes.
the system. There's also, I think I've heard the ARC a couple of times, like they usually, sometimes you just need to find like a disability-specific organization that's in your community that, where you can connect with other folks that are going through this process. Are any of you connected with like vocational rehabilitation?
Michigan
Anything like that?
Rehabilitation.
MRS, but
I know these government services provide a lot and don't often deliver. I know that can be very frustrating. But they're supposed to be the places where you can get more information about the system.
well, that's why I brought up about going through Ohio. I know that there's a program in Medina that I've had people from other states come to that program. So I was like, okay, maybe that's something. I know there's a program in Oxford, out that way. So I mean, there's a few things that are available, but none of them are close.
Right. How far are we talking?
Oxford's 3-4 hours from here, 3 hours, 2-3 hours. Yeah, and then Medina is about 2.5, 3 hours into Ohio.
I
So
mean,
it doesn't mean there's nothing close.
and your state should be supplement, like they should be helping with the, okay. So I would recommend, I think there's a Michigan Autism Alliance or something along those lines. I would look at the state level to see if they have examples of places where you can make sure that you're getting the funding to do these things. Because you shouldn't be having to go out of pocket for care.
Yeah,
For
if you go to Indiana, they cover everything, they bring things to your home, it's just amazing, Indiana is set up so amazingly, it blows my mind. I mean, it's to the point where there are a group of us actually talking about opening a center for autistic kids in the area, so that there's a place for them to live. Something that will be supervised, so that they're not completely on their own, it gives them a little bit of, independence and things like that. And to start getting some grants and things together to get this going.
Do you have, are you all familiar with the Medicaid waiver? Are you-
I am,
you
just
getting
because
them?
of long-term care, no, we're not,
Are you on wait lists for them?
no, we make too much money,
But the child doesn't make any money.
doesn't matter, they're still looking,
Yeah,
they've
you
been
look
looking,
at all of
they've
that.
been looking at my income from day one.
Yeah.
And I've got back bills for tens of thousands of dollars, because she needed a certain medication that all of a sudden wasn't paying.
But you're saying that changes when you turn 18.
I don't think it's supposed to, but.
No, they do, cause I've literally been trying to get
So
her on
if your
Social
parents
Security
have
for
a
years.
lot of money, there's a bunch of forms you have to fill out, cause I fill them out all the time, for the student when they turn 18 or when they are becoming 18, then they get services for themselves that is not dependent on parents.
Right.
In Wayne, Monroe County is a different beast, I've tried, really, that's why I'm here, to find out something, but, I know how it works in Wayne County, and there is a special ed college in Kalamazoo, it's changed names a million times, funded by the state, it's not for you, and TCI, I don't know, my students are not eligible for it, but it is run through the state and it doesn't cost you anything, and it's a live on campus situation.
I think there's something through Western that does that.
It's called the Michigan Career and Technical Institute.
That's it.
It's
That's
in
the
Plains, it's in Plainswell, Plainswell, yeah, which is outside the Kalamazoo area.
I'm not sure if my daughter would follow that.
And you would have to, go through, MRS.
There's an IQ requirement too.
There are requirements, I mean, you have to look at it, but, and you have to go through MRS in order to qualify.
MRS is wonderful in Wayne County, like I deal with them all the time, and MRS is wonderful. I don't know how it is in Monroe County, but my people are very receptive to helping.
I have a good relationship with them so far. Again, I'd like to thank you all for coming, and again, thank you, Christine, for making the long drive over here.
Thank you very much.
Is that-
I sent you my message.
Yes.